Good morning. Good morning. Hey, everyone. Wake up, wake up, wake up, wake up. Wake your friends up, send them messages so they can join the live. I just wanted to know am I clear? Am I audible? Can you see me? Can you hear me? Please just type in the chat box. Am I clear? Am I audible? Somebody? Good morning. Hey, Reina. Up and early. We're ready to do this. Today we are dealing with intestate succession. So, yesterday we had a live session where we were dealing with intestate succession. We dealt with the definitions, we dealt with, the difference between an executor as well as a trustee, because that's important to know. We dealt with the validity of a will, how a will is supposed to look like, just stuff relating to testate succession. So if you have not watched yesterday's live, please do that after this one so that you get the first part of things and then this as well. Because if you don't watch all the lives, then you won't be able to fully benefit from these sessions. So you start with testate or intestate, and then later on today we are going to do the L&D account. So, good morning and welcome. Thank you so much for joining me on this beautiful, bright Saturday morning. My name is Shella, or you can call me your lawyer bestie, and I will be hosting these sessions to help you prepare for board exams. The reason I do this is simply because when I was a candidate attorney, I had little to no help. So, I just wanted to be of help to somebody who could use it. Um, so don't be shy. Please interact in the chat box. If I ask a question, if I crack a joke, you can just write like ha 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 in the chat box so that I don't feel like I'm speaking by myself. And I also just want to say that today's session is going to be very interactive. So I hope you've got your pen and paper ready, because where I'll be asking questions, I won't be providing the answer. We are literally going to be discussing the answer so you know how to calculate certain things. So if I just give the answer to you, like you'll just look at the answer and just like know the final answer, but don't know how to get to the answer. So today's session, I want us to go through the calculations very thoroughly so that by the end of this, you know how to deal with intestate succession and the calculations relating thereto. And then I also just want to say that the thanks feature here on YouTube has been enabled. And I see that a lot of you, some of you have tried to use that one, and I really, really appreciate it. However, I just want to say that YouTube takes a big chunk of what you send. So I will just put my banking details over there so that you can rather make transfers to my account instead of using the thanks feature, because your donation is not received as you intend. But just know that this is in no way compulsory. I'm just really passionate about doing this. Passion over profit. That's literally what it is. But for those of you who do desire to send me something, you can do that directly to my account. And then, yeah, I just want to say that the one thing that I do require though is that you like this video and that you leave a comment, be it on LinkedIn or on TikTok, on YouTube, wherever it is. It really is encouraging not only for me, but for those who are going to be watching this as well. They'll be like, oh, yeah, it has benefited a lot of people. So this is worth a watch. We know how it's like when we watch videos that are over an hour. If you scroll down on the comments and people are not really saying anything that motivates you, it's like, maybe this is not worth my time. So when you leave a comment, it motivates me and other people to keep watching, and it's going to benefit them. I believe that these sessions are going to benefit you when you write your exams. So that is that. Let's get to the business of things this morning. And we're doing intestate succession. Let me just share my screen. This session is not going to be long. The notes are not a lot. So there isn't a lot when it comes to interstate succession, but it can be quite a bit if you don't know what you're doing and then you're like super confused. So yeah, we've got that. Can everybody see the notes? Or should I enlarge the font? Because yesterday I remember there was an issue where candidates expressed that the notes are a bit blurry. So I tried to zoom them and they looked a bit better. Um, is everybody seeing? Can you read what's on the screen? Okay, we can see the notes and they're clear. Because I had already saved, another version of the notes where the font was like 20. It was so big. And the notes seemed so long because the font was huge. But I'm glad that today the notes are clear and then we can get to the business of things. So interstate succession. This is when a person dies without a will. This is the basic explanation of what interstate succession is. Now, when it comes to interstate succession, you will have to underline, have to use the Interstate Succession Act. That's the act that governs estates that die without a valid will. Also note that interstate succession also applies where a person dies partly testate and partly intestate. So the provisions of the Interstate Succession Act will then apply. So even when we do the examples, you will see that I stress a lot on the act, and then you'll see the sections as well. When the life ends, please go back to the Interstate Succession Act and read the sections that we dealt with. Like I told you yesterday, the act is somewhat like a memo. The examiners will mark you based on what is on the act. So you can put a whole lot of nothings and still not get marks because what you have put in does not comply with the act. So when you write your answers, make sure that they're in line with what the act says. So when it comes to interstate succession, the broad principle is followed. If the testator is survived only by a spouse, the spouse inherits the interstate estate. If the testator is survived only by descendants, they inherit the estate per stirpes. Remember, we dealt with the definition of per stirpes. They inherit per stirpes. If there's a combination of a spouse and descendant, um, descendants being children and grandchildren, they inherit the estate jointly in specific shares. Now, on this third point, I want to say that if a spouse dies, leaving the other spouse as well as children and grandchildren, grandchildren are not going to inherit if the children are still alive. If the children of the deceased are still alive, if all of them are still alive, grandchildren are not grandchildren are not going to be able to inherit. So remember the definition of per stepes yesterday, that it is an inheritance by representation. So if a person is alive, they don't need representation. That means that the inheritance is theirs. But if a particular child dies, then their children steps into their place. You will see all of this play out in the practical examples. All right. I see a question. For the purposes of interstate succession, is it necessary to memorize the sections? No, don't. I mean, I'm not saying don't, but like I say don't because it's like section 2, 1, A, B, Roman numeral. Like you don't want to confuse yourself like that. There's a lot to know, there's a lot of calculations, but you're not going to be penalized for not writing the section number. The examiners want to know that you know the section, not necessarily that you know the section number. And this thing also of writing a vague statement and then say in accordance with section 2, you're not going to get a mark because you're not showing that you understand the content. You have memorized the section number, but you don't understand the content. So if you're absolutely, absolutely sure, obviously the examiners will be impressed. Will they give you more marks? Absolutely not. But if you don't know the section number, but you know what the section says, you're absolutely good. I hope that answers you. Okay. Then the next thing is that if there is no spouse or descendants, the testator's parents and or descendants, collateral relatives of the testator, inherit the estate. If there are no parents or descendants of parents, grandparents and other collateral relatives inherit the estate per capita. So we are going to be dealing with this in an example way where we do examples and then, you can understand this theory better. Right. So Section 1 of the Intestate Succession Act is important when it comes to the heirs. So you've got things like the spouse as a sole heir, spouse and descendants, spouse and, grandchildren. Like, it just gives you different scenarios and how to deal with them. It seems like a lot, but it's not a lot. Once you know this, and you're good to go. Right. So you've got the first thing, which is section 11A, and that is the spouse as the sole heir. So this is where there are no descendants. So according to this section, the spouse inherits the entire estate. If the parties are married in community of property, so it'll be deemed that the half share goes to the spouse, and then because of section 11A, the other half also goes to the spouse. Now, obviously, when you write your answers in the exam, and let's say the people are married in community of property, to show that you understand the theory, you can say, let's say the estate is, let's say, 1 million rand. To show that you know your theory, you can say by virtue of the spouse being married to the deceased in community of property, they get half share, which is 500,000. And then by virtue of section 1 or by virtue of the act, they receive another share because by virtue of the act, the surviving spouse is supposed to get the whole estate. And then you can say the other half also forms because of section 1, or you can say because of the act. So that shows that you know the content. If the parties are married out of community of property, you don't have to put in community of property half share. No, you'll just say that according to section 1, the surviving spouse is the sole heir and they inherit the entire estate. And then in a polygamous customary marriage, if the deceased was a husband and is survived by wives but not survived by descendants, the estate is divided equally between the wives. And I'm guessing vice versa. If the wife is survived by many husbands, then it'll be, the husbands will get the estate, which will be divided equally among them. So that is section 1. And I think we are fine with that. Are we okay with section 1? Guys, today your fingers must be on the chat box because I'm gonna need some interaction, please. So are we okay with this? Quote the sections in the exam? No, you don't have to quote the sections. Just show that you know. The best way to just protect yourself from sections is just say according to the act, because you know that you're dealing with the Interstate Succession Act. Just be like, according to the act, this is what's what. But don't go to the state of memorizing the sections and confusing yourself. I'm not saying don't, but just if you're absolutely sure, then you can write it. But if you're not, it's not a train smash. Now we've got the second thing, which is descendants as sole heirs. So this is where there is no surviving spouse. So what happens with descendants? With descendants, the children will inherit the estate in equal shares. So if there are 4 children, then they will inherit it. It'll be the estate will be divided into 4, and then the children will get, their share, their quota, like that. Each will get their quota. Right. So here is an example where there's no spouse. It says Jacob died intestate, leaving behind 4 children named Dinah, Reuben, Naphtali, and Issachar. The balance for distribution is 1 million rand. Dinah died while giving birth to her twin boys, Benoni and Benjamin. Dinah was married in community of property to Samson. Issachar is married out of community of property to Label. Who will inherit from Jacob's estate and how much? Now, when you read the question, it seems like a lot of information, but always remember the basics. What are the basics? The basics are that if there is no spouse, that means that the children will inherit in equal shares. So in this scenario, Jacob has 4 children. So we know that the estate must be divided by 4, not by 6. Don't say, 4 because of the 4 children and then 2 because of Benjamin and Benoni. No, you say 4 children, right? Divided by 4 children. Now, the as you are awarding to each child, when you get to Dinah, you know that Dinah is not alive anymore. So Benoni and Benjamin will take Dinah's share in equal parts. These type of questions, they will put this one as married in community of property, this one out of community of property with accrual with this and that, and this one, and this one, and this one. They will put all these facts, but it does not take away from the basis. And the basis is that where there is no spouse, it is the children or the descendants who inherit. So don't mind the whole marital regimes. The marital regimes have no, they don't, like, you don't involve them in this. The marital, I mean, the children being married has no standing, like it's irrelevant in this circumstance. So you can't say that, you can't say that because this one is married, then it disqualifies them. No, there's no such thing. So don't worry about, the marriage. It's part of the set of facts to sort of throw you off if you don't know your theory. So how do we do this? We say 1 million rand divided by 4 descendants, which is 250,000 for each descendant. Dinah has died, therefore Benjamin and Benoni will get her share. So 250,000, which is Dinah's share, is divided by 2 for Benjamin and Benoni. So Benjamin and Benoni get 125,000 rand each. So when you are listing who is getting, you say for Dinah, it will be Benoni and Benjamin who will get 125,000 rand each, and then Reuben 250,000, Naphtali 250,000, Issachar 250,000. Yes, I see here Samson and Lebo will not inherit. Absolutely. Yes, and Reina, you're correct as well. That is the correct answer. Right. So you guys understand this part. So you understand where there is just the spouse gets everything. If there is no spouse and they are descendants, this is how you deal with it. Reina's on fire. Reina studied, guys. All right, so now we've got a spouse and descendants as heirs. This is where a lot of people get thrown off. So if you're confused, please let me know so that we can go slower. Right. So where there is a spouse and there are descendants as heirs, there is something called a child's share or a child's portion. Now, I did not make this up. You cannot make this up. This is in accordance with the Act. So the amount that is a child's share right now is 250,000 rand. So don't try to be smart and create your own amount. No, don't do that. The amount is 250,000. That is child's share. It doesn't change. For purposes of what you're going to be writing when you write your exam, it's 250,000. So that's that, right? So what happens is with the child's share, this is only for the surviving spouse. So if there is a spouse and descendants, don't say the child gets the child's share. No, the child's share is for the surviving spouse and the surviving spouse only. So the spouse will inherit the greater of 250,000 or a child's share of the estate. of the intestate estate, and the descendants inherit the residue, if any. So what they mean by the greater of 250,000 is that 250,000 is the minimum that the spouse can inherit. 250,000 is the minimum. And then it cannot be lower than 250,000. Let's look at this example so I can elaborate this further. So if the distribution amount is 300,000 and the deceased has a surviving spouse and two descendants, you don't say 300,000 divided by 3. When you do that, it'll give you 100,000. So 100,000 is less than 250,000. So when you deal with child's share and the estate is small, you take out child's share first. You see, like it says here, a child's share of the intestate estate, and the descendants inherit the residue, if any. So the child's share takes precedent. So obviously, to determine whether you are going to give the spouse 250,000 or you're going to give the spouse more, what I like to do is I will start by going, to the amount that is given and then divided by the number of heirs. So divided by the two descendants and the spouse. That's when I am sure, because now I can see the 100,000 is less than 250,000. Then I cancel it out. Then I start by subtracting the child share first. So seeing that 100,000 is less than the child's share, start by subtracting the child's share from the amount available for distribution. So the surviving spouse getting child share first, right? And then the residue of 50,000 will be divided equally among the descendants. So that's that. But here is a trick. If the question comes like this, you've got 300,000 that must be given to the surviving spouse and two descendants. And the theory says that the parties were married in community of property. The answer is going to vary. Why? Because if the parties are married in community of property, you don't start with child's share. You start with the joint estate, half of the joint estate going to the surviving spouse. So in that case, your answer is going to vary. Although I have not seen a question where the joint estate, I mean the residue from giving the surviving spouse half of the joint estate be less than the child's share, but your answer will be very, very different because now you have to take into account that the parties were married in community of property. And I also want to say that when you read these questions in the exam, highlight certain things. It makes a big difference if they state that they were married in community of property. It makes all the difference because if you don't take that into account, your answer will be completely wrong. And when it comes to these calculations, if you miss one thing, if you don't remember something in terms of the theory, you are out. So you need to read the questions carefully and know what to do. Right. So now we've got another example where the balance for distribution is 840,000 and the deceased has a surviving spouse and two descendants. Right. Remember how I said I check if we are going with child share or we are going with a greater amount? I start first by dividing the amount that is available for distribution by the number of heirs. In this instance, how many heirs are there? There are three heirs. So I say 840,000 divided by 3, and the answer is 280,000. Now, you might be thinking, where's the child share? Remember the theory when it comes to the child share. The theory is that the surviving spouse will get 250,000 Rand or more or more. Remember, when you come to the portion of the child's share, that is where you have done this, where you have divided by the number of heirs, and that amount that you get to is less than the child's share. So if the amount that you get to is less than the child's share, you start first by taking out the child's share. Then the residue would be for the descendants. Does that make sense? Because that is extremely important. That makes all the difference in your calculations. Do you guys understand that? Okay, so we are good with that. Now, let's continue with this example, but let's assume that the deceased had two surviving spouses. So this will obviously be in accordance with customary unions and two descendants. Do both spouses get child's share, or is the child's share only for the first spouse? Do both spouses get child share, or is child share only for the first spouse? Talk to me, guys. Is the child share for both spouses or for one spouse only? Okay, I see both spouses get child share, and that is absolutely correct. Like I did with the example, it's two descendants, two surviving spouse, 840,000 divided by 4. It gives us 210,000, and that is less than the child's share. So if it's less than the child's share, then we discard that calculation and then we start by taking out the child's share first. Then spouse one, you give 250,000 for child share. Spouse two, you give them 250,000 rand for child share. And then the residue, which is 340,000 rand, is divided by the number of descendants. So because there are two descendants, they will receive 170,000 rand each. That is each descendant. So are we okay with multiple surviving spouses and inheritances for descendants? Can we move on now? Oh, and then just note that where the intestate estate is not sufficient to provide each surviving spouse with a child's share, the estate shall be divided equally between such spouses. So, for example, if the amount available for distribution is, let's say, 400,000. So already where there are two spouses, you can't give both of them the child's share because the amount is not a lot. It's not enough. So what you do is you must divide the estate equally between the spouses. So the spouses will get 200,000 and 200,000, and not the child's share of 250,000. And please just note that the child's share is also referred to as the child's portion. So if you get either or terms, don't be confused like, what is child's portion? I never knew what that is. No, you know exactly what it is. It's the child's share. Right. Now we've got parents, as there are certain instances where parents can be heirs, and that is if a deceased person is not survived by a spouse or descendants, but is survived by both parents. His parents inherit the estate in equal shares. If there's only one parent, then the one parent, inherits the whole estate. Remember that parents don't have the whole, like with parents, if there's just, parents only, the estate goes to the surviving parent. If there's two of them in equal shares, and then if there's one, it just goes to the one parent. But there's also situations, let's look at section 11D, that if a deceased person is not survived by a spouse or descendants, but is survived by one of his parents, the surviving parent inherits half of the intestate estate, and the descendants of the deceased parent the other half. So section 11D, the first part, parents as heirs. Okay, let me explain this again. I made a mistake. I see here that if there's one parent, right? And then the other parent has children, so meaning the siblings of the deceased, then the siblings of the deceased can take the part of the parent. It says here, if a deceased person is not survived by a spouse or descendants, but is survived by one of his parents, the surviving parents inherits half of the intestate estate, and then the descendants of the deceased parents can get the other half. So that is your siblings or half siblings. And then if there are no descendants, the surviving parent inherits the entire estate. So also with parents, it's similar to the descendants, that if this one is not there, then perstopies will apply. And then where there are no heirs, if there is no surviving spouse, no descendants, parents and all other blood relatives are deceased or they cannot be located, the estate is paid to the guardian's fund, and if not claimed within 30 years, it is forfeited to the state. And then we've got adopted children. An adopted child is deemed to be the legal child of his adoptive parents. He cannot inherit from his natural parents. This is important. He cannot inherit from his natural parents and their blood relatives. He is not considered to be the descendant of his natural parent unless the natural parent is also the adoptive parent. The natural parent was married to the adoptive parent at the time of the adoption. So, with adopted children, if a person has given away their child for adoption, if that person dies, the adopted child is deemed as if they've never existed. They are not counted in the number of descendants. They cannot inherit from their blood parents. Why? Because they are deemed to be the child of the adoptive parent. So you cannot inherit this side because these are your blood relatives, and then inherit this side because this is your adopted family. No, you cannot do that unless the natural parent is also the adoptive parent. The natural parent was married to the adoptive parent at the time of the adoption. So just know what the regulation says, so that if they say adoption, don't just jump and say, yes, I know when it comes to adoption, the adopted child cannot adopt from their blood relatives without knowing what the exceptions are. So always read the questions carefully and know the exceptions, know what the rules say, so that you're able to tackle the questions well. So now we've got children born out of wedlock. Having been born out of wedlock shall not affect the capacity of one blood relation to inherit the intestate estate of another blood relation. So being born out of wedlock, same with adopted children, those children are not seen as outsiders or strangers, but they are also considered to be children or descendants of the deceased. And then we've got children conceived but not yet born. I like this one in the exam. I've seen it quite a lot of times in the past papers, so just know this. Children conceived but not yet born. So when a child is conceived and the woman is pregnant, and let's say the husband dies before the child is born, when the child is born alive, they must inherit. So if the division of the estate is done while the woman is still pregnant, what you say on that child's portion, not child's portion as like, the one for the spouse, but like the child's inheritance, you will say that the unborn child will receive X amount subsequent that they are born alive. That makes all the difference. So if the child is born alive, then they can inherit. So that's what the law says. Um, so if the child is not born alive, remember that the child has no descendants. So you can't say then A and B will step into the child's place because they are the descendants of the child. No, that's obviously impossible. So just remember, Nasciturus fiction. Yes, remember that. And then we've got renunciation if the surviving spouse is also entitled to inherit. So if a descendant of the deceased, who together with the surviving spouse of the deceased is entitled to a benefit from an intestate estate, renounces his right to receive such a benefit, such benefits shall vest in the surviving spouse. So where you've got a scenario where somebody decides to renounce and not, accept the inheritance, then their part will fall to the surviving spouse. So that's how that is done. We are now going to move to the questions. Are we okay on the theory? Can we do this practically? Are you ready to take out your pen and paper and calculator and do these theory questions? Are you ready? Or do you still have questions on the theory? Or are we ready to move on to the more practical aspects of things? Okay, I'm getting reactions. I'm guessing we can move on and do the practical questions. Okay, now let's see if you understood the theory. Now we're dealing with, okay, we've got questions here. So now we are dealing with this question. It says that X dies intestate. He was married in community of property to Mrs. X. He is survived by Mrs. X, and there are two major children who are both unmarried. Now, remember the theory and always read the question, read each and every single sentence to try to ascertain what is requested of you. So already, if a question starts by saying X dies intestate, now remember we are dealing with the Intestate Succession Act. Next sentence, he was married in community of property to Mrs. X. You already have it in the back of your mind that there's going to be a half share that goes to Mrs. X. It says he is survived by Mrs. X and there are two major children. Then you're like, oh, major children, keep that in the back of your mind. Because if they say repudiation, you know that, oh, it's only minors and, people who are mentally ill who cannot renounce an inheritance. We doubted that yesterday. So as you're reading the question, just think about the theory and how you're going to deal with the question. And then it says that the net joint estate has a value of 610,000. B renounces its inheritance. How will the estate be devolved? Take out your pen and paper and start writing so that we can discuss the answer, and then you can see that you are on the right path. Okay, so in such a question, how do we start? We start with the fact that the deceased was married in community of property. What do we do there? We say 610,000 divided by what? Yes, number one, we deal with the marriage. 610,000 divided by what? It's divided by 2 because you must get the half share. Then you say 610,000 divided by 2, and then that is 305,000, which goes to Mrs. X by virtue of being married in community of property. Yes. Right. So now you've got 305,000 Rand, which goes to Mrs. X, which means that there's 305,000 Rand left to distribute the amongst the heirs. Now, this 305,000 Rand, do we divide it by 2? Because there are two heirs, because there are two major children who must inherit. Do we take the 305,000 Rand and divide it by 2? No, we don't divide it by 2. We must deal with the child's share. Remember, child's share is 250,000 Rand or an amount which is greater. So how will you know that an amount is greater? You start first by saying 205,000 Rand divided by 3. And the answer is 101 thousand rand, already you can see that that is small compared to the child's share. So you leave that part out, and then you say 305,000 rand less child's share. Yes. Then you say 305,000 rand less child's share. How much is that? Is now 55,000 rand. How did we get to that? Remember, the 610,000, we started first with the half share in community of property to Mrs. X. Then after that, we took the 305,000 rand. We took the 305,000 rand and we divided by 3 to see which one is bigger, child's share or that. And then the answer came to just over 100,000. So we saw that child's share will have to take precedence. So from the 305,000 rand, you must less the child's share. And then after you have taken out the child's share, you are left with 55,000 rand. Remember what the theory says. The theory says that child's share takes precedence. You deal with child's share first, and then the residue is for the heirs. Then child A will receive 27,500 because 55,000 divided by 2, the 2 heirs. Child A will receive 27,500. Child B will receive 27,500. But child B chose to repudiate, to renounce. Child B chooses to renounce his share. Now, how do we deal with that? Now we go back to the theory. The theory tells us that when a person renounces, their share goes to the surviving spouse. So what do? Now we must calculate how much the surviving spouse is getting. The surviving spouse is getting 305,000 because of community of property, half share. The spouse is getting 250,000 because of child's share. Then the spouse is also getting B's portion, which is 27,500. So you add those amounts together. The amounts are 305,000 rand plus 250,000 rand plus 27,500, which is 582,500. So that is what goes to Mrs. X. And then child A will receive 27,500. Now, to show that you have done the calculations well, when you add what you have given to the respective heirs, it must amount to the amount that you were given, the amount that is supposed to be distributed between the heirs. So if you add Mrs. X's share and child A's share, it must give you 610,000 because that is the amount that you had to deal with. So if you add the two amounts and you get an amount which is greater or lesser, there is somewhere in the mix where you got things wrong. Let's see. Yes, Reina is absolutely correct, you guys. This is how it's done. Do we all understand how to deal with this type of question? Are we okay? Okay, I'm getting reactions. I'm guessing we are all fine. We are all okay with the calculation. So you can see that, guys, this is easy. When you know the theory, these calculations, they can try to throw you off. They will say, oh, the two major children, this one was married to Tom, they got divorced, and then they had one child from the first marriage, three children from the second marriage. They adopted one child. They did this, they did that. Don't let all of that confuse you. Know the theory. What does the theory say? The theory says that, children born outside of wedlock, children, illegitimate children, all those people, they are on the same footing as children born in marriage. So the question might try to throw you off and say, this one had an affair with this one, and then a child was born, and then this one was born in this way, this one was adopted, this one was this, but it remains one thing. Those people are descendants. So you must always take that into account. Even when you read the facts, just know that somewhere they will try to throw you off. But when you know the basics, when you know the theory, you should be okay. All right. So now we are dealing with this question. It says you are the executor in an estate, which a cash sum is awarded to a 17-year-old beneficiary. Wait, I see. No, we divide by. Oh, okay. You are the executor in an interstate estate, which a cash sum is awarded to a 17-year-old beneficiary. To whom would you pay the benefit? So if the beneficiary is a minor, like you see here, we're dealing with a 17-year-old. The 17-year-old will not be allowed to receive the money because they're still a minor. So it'll be put in the guardian fund or the minor's natural guardian, provided that they provide security to the master. So there is in no way that the 17-year-old can receive the cash sum. Like we said yesterday, here, when it comes to inheritances and stuff, capacity is not influenced by status. So even if the 17-year-old is married, the fact remains that they are still considered to be a minor for purposes of this. So the money must be paid to the guardian fund or the minor's natural guardian, and then they can receive it once they attain the status of majority. Now we've got another question. It says that Nimrod Ntuli died on 2 January 2009 as a result of gross overindulgence during the New Year's party. He was a bachelor, no will can be traced. As far as can be ascertained, he had no children and he was the only child of his parents. No living relatives can be traced. No, who inherits Nimrod's estate? Who will get, you know, whatever from Nimrod's estate? How will this be reflected in the distribution account? Just know that the executor must award the balance available for distribution to unknown heirs in the distribution account. The amount must be paid to the guardian fund, and if unclaimed for 30 years, it is forfeited to the state. Now, remember, when we deal with things like the liquidation and distribution account, there is a part where the executor, remember yesterday we dealt with the role of an executor, and one of the roles of the executor is to make sure that the creditors know that the L&D is lying for inspection. Remember those advertisements? We've got advertisement in terms of section 29, and then we've got advertisements in terms of section 35. Now, those advertisements are important because people can see in the newspaper, they can say, oh, okay, Nimrod passed away, and there isn't somebody, like there aren't any like beneficiaries and things like that. And if somebody is related to Nimrod and they can see that, and then they can, contact the executor and say, I am, let's say, Nimrod's, adopted sister. I moved to another province, and after I saw the ad, this person has a claim against the estate, and obviously the executor will then have to validate the claim, the claim, and then the claim can either be rejected or accepted. Now, all of this will deal extensively when we deal with the L&D account. So I want you to know that advertising the L&D account is of importance for matters such as this. Because if these things are not advertised, then the relevant people cannot come forward, because how would they know? So these things are of importance. Now we've got another question. We're literally almost done. We're almost at the end of the session, but we've got another question. Where Zwane died intestate on 26 November 2014 and is survived by his wife Dudu, to whom he was married according to customary law in 2011. No antenuptial contract was entered into. Dudu is 7 months pregnant with Zwane's child. Zwane is also survived by the following people. A, his minor son Joshua, his minor son Joshua, who renounces his right to inherit. Now, the theory must already be clicking in your head. Minor, renouncing. You must already be thinking along those lines. And then B, his father Soli, who has paid for the funeral expenses and does not require to be reimbursed. C, his younger sister Rose, who was financially dependent on Zwane. The net estate is worth 900,000. Advise Zwane's family as to how to deal with this estate and who's going to get what. Give reasons for your answer. Let's go, let's go, let's go. How do we handle such a situation? There's an unborn child, there's a father, there's a sibling, a spouse, a minor who is renouncing. How do we deal with this? Let me give you a second. Right, so we've got the 900,000, which is available for distribution. How do we start? From the set of facts, it says that Dudu was married in accordance to customary law. There was no antenuptial contract that was entered into. What does this tell us? This tells us that there must be a half share to the spouse. So it is in community of property, yes, Mashudu. So half share to Dudu. So already point of departure, half share to Dudu. So 450,000 to the surviving spouse by virtue of marriage and community of property. I also just want to say that when you write these answers in the exam, please don't write them like you're writing a maths test. Don't just put numbers. Put numbers and explanation. Explain what that number is for. If you are putting 450,000, you say divided by 2. Say divided by 2. Why is it divided by 2? Then you write in community of property because it shows that you know the theory. And then, so you've got number one, half share, 450,000 goes to the spouse, right? Then what is left is 450,000. Now we need to determine how many people are going to inherit from this. Now we read the facts again. Okay, Dudu, we know Dudu. Dudu's unborn child, is the unborn child going to inherit or not? Yes, the unborn child is going to inherit. So we've got one person already who is going to be a beneficiary. Then we read the facts again. His minor son Joshua, who renounces his right to inherit. Is Joshua going to inherit? Yes. Why? Because Joshua can't renounce. He is a minor. So we've got two people already. Then we move to B, his father Solly, who has paid for the funeral expenses and does not require to be reimbursed. Is Solly going to inherit? No, Solly is not going to inherit. So we are still left with two people, two descendants. Then C, his younger sister Rose, who was financially dependent on Zwane. Is Rose going to benefit? No. So now we've got Dudu and two children. How many people are there? 3. What do? We say 450,000 rand divided by 3. It gives us about 150,000. So about 150,000 is less than child's share. What do? We take that 450,000. We start by minusing the child's share. So 450,000 rand minus the child's share equals to 200,000. So we have dealt with Dudu's portion. Now 200,000 will be divided by 2. Divided by 2. Then you have 100,000. You say 100,000 to the unborn baby if born alive. Don't just say to the unborn baby, because what if the unborn baby is not born alive? Then what? You must write so that the examiners know that you know the theory. So you write 100,000 to the unborn baby if born alive. Then 100,000 to Joshua. Right. Would your answer be different if Joshua was a major? Yes, if Joshua was a major, right? If Joshua was a major, then the 100,000 which belongs to Joshua was going to belong to Dudu. So let's say that Joshua was a major. Yes, Reina, you're correct. So let's say Joshua was a major. How would things be devolved. So it'll be 450,000 rand, which belongs to Dudu by virtue of marriage and community of property, plus 250,000, which is the child share, plus 100,000, which belonged to Joshua if Joshua was a major. Then Dudu was going to get 800,000, and then the unborn child, if born alive, was going to get 100,000. And then even if Joshua was a major, Solly and Rose still get nothing. So that is how the answer was going to be if Joshua was a major, but Joshua is a minor, so he cannot renounce his claim. Is that clear? Are we okay with that one? Are we okay with that? I think we're okay. It looks like we are somewhat okay with that. Okay, I'm getting why can't Solly and Rose inherit? Good question. Why can't they inherit? The reason they can't inherit is because we follow what the act says. Here is not about sentiment, it's about the act. So let's go back to what the act says. So, in accordance with the provisions of the act, descendants and spouse, they rank higher than parents. Let's go to the parents as heirs. Right. Parents as heirs, section 1(1)(d). It says if a deceased person is not survived by a spouse or descendants, let's stop there. If a deceased person is not survived by a spouse or descendants. So that is why Solly and Rose cannot inherit, because in this set of facts, there is a spouse and there are descendants. So if spouse and descendants are not available, that is when parents can step in. Does that make sense? So parents don't just step in randomly and siblings, no. We look at the act and see what the act says. The act says if there are no spouse and if there are no descendants. So meaning if there is a spouse and there are descendants, then parents can parents, if there are no spouse or descendants, parents can inherit. But if they are there, parents cannot inherit, because when it comes to the hierarchy of inheritances and things like that, spouse takes first precedent, then descendants. Always remember that spouse takes first precedence. How do we know that? We know that because even when you divide the amount for distribution and the amount for child share is less than 250,000, you must still take out 250,000 rand and leave the other descendants to share the residue. So the spouse ranks higher. The spouse ranks higher than the distance. Does that make sense? So don't ever make the mistake in the exam where you deal with everybody else's portion first, but you don't deal with the spouse. You start with the spouse. Things like, when the parties are married in community of property, you start with the spouse. Then after that, you go to the child's portion. So meaning that you don't go to anybody else until you have dealt with the share of the spouse, because that takes precedence. And in circumstances where, let's say, there are two surviving spouses and the amount for distribution does not allow for the child's share. Let's say the deceased had two spouses and the amount for distribution is only 200,000. So we already see that the two spouses cannot get child's share. But because the spouses rank higher, that amount, that 200,000, will be divided equally between the two spouses, and the descendants will get nothing. So there's a hierarchy to this thing. So does that make sense? Does that make sense why parents cannot inherit when a person has a spouse or descendant? Are we okay with that one? Okay. All right. Okay, I can see your understanding, which is perfect. Because we are literally at the end. Let's see. Right, we've got another question, one last question. Fastest finger on the dial. So we've got A and B who are married in community of property. A died intestate on 26 November 2015. He is survived by B, his wife. P, his minor son who renounces. Q, his major daughter who is married in community of property. R, his major son from a previous marriage. S, his father. The joint estate is worth 1,800,000. How will A's estate dissolve? Now, before you even get to the calculation, let's do this using theory. A and B married in community of property. What do we know by that? We know that B must get half share already. We know that. His minor son who renounces, we know that minors cannot renounce, so P will get his inheritance. Q, his major daughter who is married in community of property. Like I said earlier on, marriages have no effect on inheritances as long as a person is as long as the person does not renounce their inheritance, they're still able to renounce. And then R, his major son from a previous marriage. We know that children born outside of the marriage, with the surviving spouse, they're also considered children of the deceased. There is no, children who are born outside of the marriage don't rank lower than those who are born within the deceased marriage. No, they're also considered as descendants in accordance with the Act. And then S, his father, and then the joint estate is 1.8. So we know, like I said, the minor son renounces, the major daughter will also get an inheritance, and then the major son from a previous marriage as well. And then his father, because of what we have just said, will not be able to inherit. Why? Because there is a spouse and there are also descendants. So the father will not be able to inherit. Now, let's see, how do we deal with that? A and B, married in community of property. What is the amount for distribution? That is 1.8. How do we deal with that? We start by saying 1.8, 1.8 what? Divided by 2. Why 2? Why 2? Because joint estate. Then after that, what happens? Guys, are we sleeping? Are we still calculating? So firstly, we've got 1.8 divided by 2. Why? Because in community of property. So we now have 900,000, which goes to B, the wife, because marriage in community of property. What is left? What is the residue? The residue is 900,000. So now we have to figure out how many people are going to inherit. So, in addition to the wife, so we already have one person who is the wife, and then we've got P, it's 2 people now. We've got Q, it's 3 people now. We've got R, it's 4 people now. Do we add solely? No, we don't. So we've got 4 people who are going to inherit. So you say 900,000 divided by 4. Let's calculate 900,000 divided by 4, which is 200. 225,000. So 225,000 is less than the child's share. So what do? We deal with the child's share first. So we will say 900,000 minus 250,000, which is the child's share. I told you guys, when it comes to the child's share, don't be creative. This is an amount that you are given to by the act. So don't make the child's share what you want to make it. Make it what the act makes it, and that is 250,000. So what is left? What is left is 650,000. So the wife now has their half share in community of property, and they also have the child's share. So now you've got 650,000 rand, which is for the descendants. So you will say 650,000 rand divided by everybody. There's nothing else to do there. Yes, so the remaining 650,000 will be divided among P, Q, and R, and they will each receive just over 216,000. And also P cannot renounce because he is a minor, and that's correct. S will also not be allowed to inherit. I see you guys are quick. You guys know what's going on, and that is basically it when it comes to intestate succession, right? Yeah, that is basically it for intestate succession. So, marital regime, it determines how everything will be dealt with. Adiation, repudiation, always remember renouncing, accepting and declining an inheritance. Who can accept, who can decline? What happens if, let's deal with this example and say, let's look at P, right? Let's change this thing a little bit. Let's see if you guys remember this from yesterday. Let's say P. No, let's say Q, his major daughter, is the one who killed the deceased. Is the answer going to change? And the answer is yes. The answer is going to change because the one who was killed cannot inherit. Remember the bloedige hand principle. So when you are reading the set of facts, remember the principles. As you're reading, like you guys, I see here on the comments you have written, you can see this P is a minor and he also renounces. Then you go back, you remember the theory. The theory says what? That a minor cannot, it says that a minor cannot renounce their claim. So as you're reading, the set of facts and stuff, remember what the theory says. You will not be able to answer these questions if you don't read section 1 of the Interstate Succession Act. So for today, read section 1 of the Interstate Succession Act. Read section 1 of the Interstate Succession Act. It shows you how to deal with this. I've also done this in the notes. So come back and watch this thing as many times as you must. So now we are done with today's session. Do you guys have any questions? Have we got questions? Or are we all clear on everything? Guys, are we okay, or do you have questions? Okay, I'm seeing I'm good. I'm all clear. So you will know how to deal with questions relating to interstate succession. Okay, before I let you go, I just want to say that later on we've got another session and we're going to deal with the L&D account. right? So from now on until 2 p.m., there's a lot of time. Please go over Regulation 5. Please go over Regulation 5. Please. Let me, right. Let me quickly just hop onto the LND 5 part. Guys, Regulation 5 is important. I don't see how you will pass the L&D question if you don't know Regulation 5, because L&D is the easiest part of the paper. So if you don't know Regulation 5, I'm going to jump out of my phone and like slaughter you so you don't write the exam because you don't want to know what Regulation 5 is. Guys, know Regulation 5. So I'm saying this because between now, past 9, until 2 p.m., there's a lot of time. Read Regulation 5. Even if you don't understand, just read it. Read it twice. Just read it. Then when we come back, when we speak about the L&D account and I take you through everything, things are going to make sense. The aim is for y'all to know how to do the L&D account after the session. And as much as, I can, teach my heart out. If you don't know Regulation 5, there's nothing I can do. But if you know Regulation 5, even when you come for the session, you will have smart questions to ask. You won't ask things like, why must I put a heading on an L&D account? No, that question is not smart because if you read Regulation 5, you won't ask me that. Right. So okay, is it 2 p.m. or 12 p.m.? Let's make it 2 p.m. The reason why I'm making it 2 p.m. is because I had a bit of a technical issue. I'm not at my house right now, so I have to drive back to my house. So just to make provision for that time, let's make it 2 p.m. Are we all okay with 2 p.m.? Let's make it 2 p.m. And between now and 2 p.m., read Regulation 5 is what I'm asking you. You read Regulation 5. L&D is easy. Also, when you come for the session, know that this is the easiest part of the paper. This is the easiest part of the paper. And there's a lot to know, but this is the easiest part of the paper. So read Regulation 5, and then you and I are going to be besties for real when you read Regulation 5 because you're going to pass the L&D account. Even if you don't understand it, it's okay. We'll deal with it in more detail at 2 p.m. So that is that. Do you guys have any questions? Don't ask me anything on the L&D account. We're not there yet. Ask me on Testate and Intestate, what we have done today or yesterday. Do you guys have any questions? But if I end the live and you do have questions, please just leave them in the comment section so that I can answer you and, it can be to the benefit of everyone. Everyone can see, what the questions were and, maybe they've also got similar questions. So it'll be easier if we do that. So are we okay? Are we okay with what I've explained? Are we okay with testate and intestate succession? Is there anything in particular that is confusing you? If you were to write on intestate and testate succession only, would you pass the paper? Say yes or no. If you were to write on testate and intestate succession only, would you pass the paper? Yeah, I'm not seeing a yes or a no. It's shaky. Okay, Mashini says 100%. Guys, would you pass the paper if you wrote on testate and intestate only? Otherwise, the live sessions have been a waste. I'm getting yes, I'm getting yes. Okay, that's good. So we've got the 2 lockdown, and then at 2 p.m. I will see you and we will deal with the liquidation and distribution account. Don't forget to read Regulation 5. Otherwise, I'm going to jump out of my screen and like scratch your face because you can't do the LND account without reading Regulation 5. Okay, until then, I will see you. Make sure that you just go over the work and stuff. And yeah, I will see you later on. Bye.